Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. Let's break down a case that changed how courts think about this area of law. When you send a digital message across borders, where exactly is the contract made? This case changed how we view modern communication in jurisdiction, saving businesses thousands in potential legal fees. Let's break down the Brinkibon ruling and what it means for your cross-border deals today. Alright, let's start with the real-world problem. Understanding how communication methods change your legal rights is the first step to avoiding a jurisdictional nightmare. Historically, the postal rule meant a contract was formed the moment you dropped a letter in the mailbox. This protected the sender, but left the receiver in the dark until the mail arrived days later. In modern business, relying on this rule for digital communication can lead to massive confusion over which country's laws apply. You need to know if your communication method follows this old rule or the newer receipt rule to avoid being sued in a foreign court unexpectedly. When we moved to telex, fax, and eventually email, the law had to adapt because these methods are nearly instantaneous. Unlike a letter that travels for days, a telex arrives almost immediately at the recipient's machine. The courts realized that applying the postal rule here would be unfair to the recipient, who might not even know a contract exists yet. Understanding this distinction is vital when you're negotiating high-stakes deals across different time zones. The biggest risk in international contracts is jurisdiction, or which court gets to hear the case. If a contract is formed in London, English courts usually handle it. If it's formed in Vienna, you might find yourself hiring Austrian lawyers. This can lead to massive travel costs, translation fees, and unfamiliar legal procedures. Knowing exactly where the legal acceptance happens allows you to budget for these risks or negotiate a better venue up front. Now let's look at the specific facts of the Brinkibon case to see how these theories play out in a real business fight. The case involved Brinkibon, a company in London, wanting to buy steel bars from Stahag Stahl in Vienna. They were negotiating back and forth across borders using telex machines, which were the high-speed business tools of the early 80s. When you're dealing with raw materials and fluctuating market prices, the exact moment a deal becomes binding is worth a lot of money. A slight delay or misunderstanding in communication can result in one party backing out of a now unprofitable deal. Brinkibon sent a telex from London to Vienna, accepting Stahag Stahl's offer to sell the steel. Brinkibon later wanted to sue Stahag Stahl in an English court for a breach of contract. To do this, they had to prove the contract was actually made in England. This is where the technicality of the receipts versus posting became the entire focus of the legal battle. The House of Lords had to decide, was the contract formed in London when the send button was hit, or in Vienna when the message appeared on the machine? If it was London, the English courts had jurisdiction. If it was Vienna, the English courts would have to stay out of it. This highlights how a single piece of office equipment can dictate your entire legal strategy and potential costs. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. The court's decision created a rule that we still use today for most digital communications. The House of Lords ruled that for instantaneous communication, the contract is formed where the acceptance is received. Since the telex was received in Vienna, the contract was made in Vienna. This is known as the receipt rule. It places the responsibility on the sender to ensure the message actually reaches the other party, which is a safer standard for modern commerce. The court relied heavily on an earlier case called Enterprise v. Miles, Far East, which dealt with similar issues involving Dutch and English companies. They confirmed that the logic used for telephones, where you know if the line goes dead, should apply to telexes too. If you're talking to someone and the connection drops, you know they didn't hear your yes. This common-sense approach prevents people from being bound to contracts they never actually saw. Crucially, the Lords noted that this isn't a universal rule for every single scenario. They acknowledged that if a telex is sent at night or to a machine that's unattended, the receipts might not happen until the office opens the next day. This means the intent of the parties and standard business practice still matter. When you're sending critical documents, always consider the recipient's local business hours to ensure your receipts is legally valid. Understanding the law is great, but applying it to your business decisions is where you save money and avoid stress. Many businesses try to forum shop, which means they look for the court system that's most favorable to them. Brinkibon wanted London because it was more convenient and potentially cheaper for them. However, because they didn't specify this in the contract, the receipt rule forced them into a foreign jurisdiction. Never assume you can sue in your hometown just because you're the one who accepted the deal. If a dispute goes to a foreign court, your costs can triple. You'll need local counsel in that country, expert witnesses to explain English law to them, and certified translations of every email and document. These hidden costs of a contract dispute often outweigh the value of the deal itself. Identifying the jurisdiction early helps you decide if a deal is even worth the risk. In the Brinkibon era, time zones were a major factor in determining when a telex was received. Today, with email, the principle remains. If you send an acceptance at 11:59 p.m. on a Friday to a country where it's already Saturday, when is that contract formed? Always timestamp your communications and, if possible, request a manual acknowledgement of receipt. This creates a clear paper trail that prevents arguments over timing. Let's wrap up with some safe first checks and decision frameworks to protect your interests in any deal. The easiest way to avoid the Brinkibon headache is to include a choice of law clause in your initial offer. This explicitly states that this contract shall be governed by the laws of England. By doing this, it doesn't matter where the telex or email is received, the rules of the game are set in advance. It's a simple sentence that can save you from years of jurisdictional arguments. Similar to choice of law, a jurisdiction clause specifies exactly which court has the power to hear a dispute. You can agree to exclusive jurisdictions in London, meaning neither party can sue anywhere else. This prevents the other side from dragging you into a court in Vienna or anywhere else they might have an office. It's one of the most important protective measures in any international agreement. In high-value deals, don't rely on the receipt rule alone. Always include a requirement that acceptance is only valid once a human being acknowledges it. This moves the goalpost from a machine receiving data to a person confirming the deal. This prevents accidental contracts formed by automated systems or messages that end up in a spam folder. If a deal involves significant capital or complex regulations, generic templates won't cut it. You need a qualified professional who understands the treaty laws between the two specific countries involved. They can help you navigate things like the Vienna Convention on Contracts for the International Sale of Goods, CISG. Paying for a few hours of review now is much cheaper than a cross-border lawsuit later. Watch out for partners who refuse to agree to a specific jurisdiction or who use vague language about where the final office is located. If they insist on their local laws but won't provide a translated copy of those laws, that's a major red flag. Always verify the physical address of the company you're telexing or emailing. A virtual office in a tax haven can make enforcing a contract nearly impossible. While Brinkibon was about telex, the principle applies to email, Slack, and even WhatsApp in some cases. The law generally may help with these as instantaneous, meaning the contract is formed where the recipient is located. As technology evolves, the courts continue to look back at Brinkibon as the foundation for digital contract formation. Staying aware of this history helps you navigate the future of e-commerce. That's the practical version of Brinkibon the Stahag Stahl. The big idea is to understand that in our digital world, contracts are usually formed where they're received, not where they're sent. By using clear jurisdiction clauses and confirming receipt, you can avoid expensive foreign legal battles and keep your business deals on your own terms. If this helped you understand the risks of international contracts, like and subscribe to Law Conquer for more case summaries and legal education breakdowns. Stay informed, and I'll see you in the next video. Subscribe for more case summaries that make law study easier. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.